In the 1970s, Delaware police officers routinely stopped randomly chosen vehicles for license and registration checks. When one of these stops led to serious criminal charges, the constitutionality of this practice ended up before the United States Supreme Court in Delaware versus Prouse. Patrol Officer Anthony Avena stopped a car driven by William Prouse. Avena hadn't observed any traffic violation or criminal activity. He randomly chose the vehicle just to check the driver's license and registration. As luck would have it, Prouse's car was giving off a strong odor of marijuana. Avena asked the occupants to get out, and he found a cellophane bag of leaves that looked like marijuana under the front seat. Avena seized the bag and arrested Prouse. Prouse was indicted for possession of marijuana. He asked the court to suppress the evidence against him on the ground that Avena had obtained it during an illegal detention in violation of the Fourth Amendment. Delaware admitted that when Avena stopped Prouse, he hadn't had any reasonable suspicion that Prouse was engaged in criminal activity. The trial court granted Prouse's motion to suppress the evidence. On appeal, Delaware argued that its patrol officers shouldn't be subject to any constraints in choosing cars to pull over for license and registration checks, because the state's interest in ensuring safety on the roadways outweighed the intrusion on the privacy of drivers. The Delaware Supreme Court held that random stops without specific justifying facts were unreasonable because they were inherently arbitrary and created the possibility of discriminatory treatment. It affirmed the decision to suppress the evidence. The United States Supreme Court granted cert.